Hi guys, today we're going to be talking a little bit more about technology, although in a little bit of an unusual way. First, I want to kind of go through what we talked about on Monday or what you went through and read about on Monday, just to make sure that we understand the outcomes of the Supreme Court cases. I realized with First Amendment, there were some cases that people weren't necessarily understanding what the outcomes were. And the one that I most commonly saw misused was Ellen's. The Ellen's court case, I hope you realize he was protected under the First Amendment. The Supreme Court sided in his favor. He was arrested and thrown in jail later for another charge that I believe had nothing to do with, I think he attacked somebody. It was some sort of violent element, but he did not go to jail for the actual Facebook posts. His First Amendment rights were protected. The Supreme Court said it was because of it was an artistic form, and you're allowed to say what you want as long as it's art. So just be aware of that. So I wanted to talk about some of the technology that you saw. One of the first patterns you should have seen was that cars can be searched without warrants. And the reason is your car can be emptied or moved or made so that a police officer can't find it in the time that it would take to actually get a warrant. So that's the first one. Phones. Phones cannot actually be tapped without a warrant. You do need a warrant. This would be a little bit confusing. So if you saw there were two court cases dealing with phones. One was with public phones and the other was a private phone. Most of them had to do with bootlegging alcohol, and gambling. But the first one that you saw, Olmstead, it said that those things could be tapped. And then Katz actually overturns Olmstead and says that no, you have a right to privacy on your phones, and that if a police officer wants to wiretap your phone, they actually do need a warrant. So understands Katz overturns Olmstead. Other patterns, anything technology-wise that an average person doesn't have access to cannot be used without a warrant. So in the Kylo case, you saw that the average person doesn't have heat imaging material nor a helicopter to fly over a house to use said heat imaging. So that does constitute a actual search, and you need a warrant for that. And then finally, if an employer gives you a phone or a tablet to, work on, you do not have the right to privacy on that. So all your PLDs, yes, they can be searched. Yes, that's cool too, so that's always a different scenario. But anything that a work provides you with, any bit of technology, can be searched completely fair. And that was the case with Quan and how his mistress, it had something to do with mistress and how the text messages back and forth to the mistress were caught, and he was fired from his job for misuse of technology. And that was perfectly legal because, again, if your job is providing you with a device, they can search it. Just like if school provides you with a device, they can search it. All right, so that's kind of a recap. If you have questions, please reach out, but that's the big patterns that you saw on Monday. Today, we're going to be looking at, I guess you could call it a piece of technology, but instead, we're going to be looking at drug sniffing dogs. Do you need a warrant in order to use a drug sniffing dog? And that really is what you're going to be exploring today. Let me show you the assignment here. So you have a few questions. You're going to tell me what the facts of the case are. You're going to define curtilage, which is super important. We'll talk more about that on Wednesday of next week, because remember, Monday is Memorial Day, so there will be no class, but Wednesday and Friday there will be assignments. So be on the lookout for that. The article, and all of this is based on an article that I'll show you in a second, but what precedents came up from the arguments in this case? So meaning, what court cases do they look to in order to determine? Now, I will tell you the outcome on Wednesday of this court case. The article I'm providing with you does not tell you who wins the court case, okay? That fourth question is asking you to predict. Yes, you can go online and search it up. I don't suggest. I want you to think about the court cases we've already discussed and figure out, do you need a warrant in order to use a drug sniffing dog. So, does the use of Frankie the search dog constitute a search? Did Detective Bartlett need a warrant to make use of his four-legged friend's wonderful nose and try to do some explanation? And Frankie is the dog. Okay, let me get up the actual article now. So it's how did the dog sniff violate the Fourth Amendment? It's not super long. Again, it does not tell you what the outcome is. You are predicting. That's what question 4 is discussing. And again, on Wednesday, I will go over what the outcome of the case is, and it'll hopefully, be interesting. But you have enough knowledge that you could probably make a pretty accurate guess as to what the Supreme Court decided in the case of Frankie. And this court case is known as Florida versus Jardines. All right, if you have questions, reach out. Make sure you're getting makeup work to me. We are after today only have 4 more actual lessons, and then after that point, it'll be a week of catch up. So reach out if you have questions. Friday, I'll have a Zoom meeting. You do need a password now to get in. I'll make sure I post it the day before. But I'm here if you do need help. All right. Everybody have a great weekend. And remember, this assignment is due Wednesday of next week, which is our next class time. All right, enjoy your Memorial Day.